Hello guys, so in the last lecture that we were doing of class 12th legal studies chapter 1 judiciary, we have done that how the fundamental rights are preserved by the cognizance of courts, right? We have taken the example of landmark judgment of Menka Gandhi versus Union of India, wherein we saw that right to travel abroad is a fundamental right under Article 21 of Indian Constitution. And furthermore, we also covered that odi ultra partem is very important principle to be taken into consideration by the courts, to be followed by the courts, right? Odi ultra partem is a Latin phrase and it means hear the other side. So a judgment can't be pronounced without hearing one side. Both the sides are to be given equal opportunity to be heard and equal opportunity to present themselves, to present their sides in the court of law. Okay. Now let's begin with this. I've also told you that if there is a decision taken by administration about the inefficiency or corruption which is prevalent in the government systems, and administrative itself has taken a decision, and if it is not par with the constitution, then courts can intervene in between, and by the method of judicial review they can ask for the disclosure of reasons that why you have given this order. So the reasons behind giving an order किसका? एडमिनिस्ट्रेशन का, ठीक है? तो उसके रीजंस वो पूछ सकता है. This requirement holds good even when a statute or legislation does not provide for this requirement. It may be that there are some verdicts of the administration wherein there is no requirement of disclosure of reasons. If there is no requirement that such reasons should be asked from the administration, then too this requirement can be taken up or these reasons can be asked. ज़रूरी नहीं है कि हमने जो वर्डिक्ट दिया उस पर क्वेश्चंस उठे, लेकिन तब भी अगर कोर्ट का मन होगा, उसे कुछ अजीब लग रहा होगा, तो वो क्वेश्चंस रेस कर सकती है. Courts have emphasized that right to provide reasons is an inherent part of justice delivery. To deliver justice, to give justice, it is important that the reasons to give a particular verdict should be provided. This is as per the court. That's why you may have, if you have seen any order or any verdict which is in print form of any court of law, let it be High Court or Supreme Court, if you have seen the verdict, then they provide reasons for the verdict that they have announced. They provide under this section of IPC or CRPC, whatever, or under this article of constitution, this and that is mentioned, so hereby I have decided this thing. They write the verdict, they print it off, right? Furthermore, judicial method of disclosure requirements deters the practice of arbitrary action by officials and offers legal safeguard to victims. So this method of disclosing or asking for the reasons, it is important. Why? Because it helps to deter means decrease or decrease the chance of giving arbitrary verdicts by the administrative officials, and also it provides a legal safeguard to victims. Also, by notifying aggrieved about reasons, such disclosure satisfies requirements of principles of natural justice. That means if the reasons are given to the aggrieved, means to the victim, if the reasons are provided that these are the reasons and these are the things by which you are gonna get the justice, or if it is a accused person, then two reasons are provided to him that under this or that section you are gonna be sentenced, and as per this section you will be given this many years of imprisonment or fine or whatever it is. So the reasons are provided to both victim and the aggrieved or the accused person, so that the principle of natural justice can be satisfied, and also there should be a justice delivery, that this should not be justice as it looks only, but it should seem to be justice. Justice हो रहा है ये सिर्फ दिखना नहीं चाहिए, justice होता हुआ भी दिखना चाहिए, right? ऐसा लगे कि हाँ justice हुआ है, ठीक है? So that is also important. So principles of natural justice को satisfy करने के लिए aggrieved को भी reasons दिए जाते हैं कि आप इस account में punish जा रहे हैं. Courts have been using principle of reasonableness in most cases that involve state action. Reasonableness means this action is how much reasonable. Like we say that fundamental rights are absolute. Yes or no? No. Fundamental rights are not absolute. The freedom of, for example, if I take freedom of speech and expression, it is not absolute because subject to public order, health, morality of the society, the government can impose certain reasonable restrictions on this right. So what I have said, reasonable restrictions. So what is this reasonable? Right? The court decides that what comes under this ambit of reasonableness. What could be the reasonable restrictions that can be imposed by the government in a particular state or anywhere to a fundamental right. So that reasonableness is decided by the court. If I say that someone has given a very, abusive or inciting lecture, or what you say, lecture, right? And it is against the government or the country itself, then it could disturb the morality of the people, right? The society, public order, it could disturb. So in that case, reasonable restriction can be placed on the freedom of speech and expression. You can't say that I have freedom to speak whatever I want. No. It is subject to public order as well. If you are saying some inciting languages that can incite violence in the society, then that is not at all allowed. Realm of contract law offers an example. Whenever states are parties to any contract, courts attempt to distinguish such contracts with that of contracts entered between private individuals or parties. That means if there are two state governments or two governments which are party to any contract, then in that case courts distinguishes this type of contract with that of the contract between two common citizens or between two private individuals or parties. ठीक, वो private individual के बीच के contract को government के contract से अलग कैसे करना है वो सोचता है कोर्ट. ठीक है, क्या रीजनेबलनेस, क्या रीजनेबल कंडीशंस हो सकते हैं कि हम किसी दो गवर्नमेंट के कॉन्ट्रैक्ट को और किसी दो प्राइवेट इंडिविजुअल्स या पार्टीज के कॉन्ट्रैक्ट को अलग बताएं और उनको अलग कंसीडर करें और अलग टाइप से उनको डिसीजन दें जो भी डिस्प्यूट हो उसका. In that, private contracts concern personal interest, state concerns public good and public interest, and is expected to act reasonably and not with freedom of discretion. So in private contracts, generally if two individuals, two common people are getting into a contract, then they will think about their personal interest. They will not think about the interest of the whole public or whole society at large, right? They will be concerned only with their interest, which will be fulfilled by virtue of the contract in which they are entering. Yes, if a person is ready to buy something or sell something, then he will be interested that okay, I will have this personal asset now and I will be having money after selling this. So these are the personal interests which are fulfilled by getting into a contract by some common individuals. But if two state governments are getting into a contract, then that contract has to be reasonable in the sense that it should think of the public interest and the public welfare at large, right? Another principle frequently utilized by courts in administrative law, especially in service matters, is principle of proportionality. So right now what we have done is principle of reasonableness. Now comes principle of proportionality, that the act which you have done is how much proportional. Like we said, if a thief has come to rob a house, okay? And the owner of the house, he gets awake somehow. He was sleeping at that time when the thief has entered, but due to the sound that the thief was making, the shuttering sound or whatever, the owner gets awake and he finds out that there is a thief in his house who is trying to rob something, okay? And thereby the owner takes out his gun and points at the thief. Seeing the gun, thief was very scared and he got the idea to run away without taking anything from the house. Okay, without robbing anything from the house, the thief got scared by seeing the gun which was pointed at him by the owner of the house, and so he ran away. He started running away. But meantime, the owner fired the bullet and it was at the leg of the thief. ठीक है, leg of the thief में उसने bullet fire कर दी. Now this is not proportional. What was the harm? What was the harm that was gonna happen to the owner of the house? Things were to be stolen, right? चीज़ें चोरी हो जाती, या thief उसको कुछ मारपीट करता चीज़ें चुराने के लिए, लेकिन यहाँ पर गन देखते ही जो चोर है वो भागने लगा था. तो उसको कुछ डेंजर नहीं था, ओनर को कुछ भी डेंजर नहीं था थीफ से. ना उसका कोई सामान चोरी हुआ था और ना उसको वो खुद मार रहा था, तो कुछ डेंजर नहीं था, तो आपको गन फायर करने की कोई ज़रूरत नहीं थी. ठीक है, सो दिस इज द अनप्रपोर्शनेट हार्म विच द ओनर हैज़ डन टू द थीफ. ठीक है, सो दिस इज हाउ द प्रिंसिपल ऑफ प्रोपोर्शनैलिटी इज चेक्ड on various disputes. This was just an example that I have given you for better understanding. Essentially, judicial review offers safeguards to aggrieved against any sentence or punishment that is disproportionate and burdensome. If there is any punishment which is disproportionate to the crime he has committed, then by virtue of judicial review he can get some relief from the punishment. Punishment कम हो सकती है, कम साल उसको जेल में रहना पड़ेगा या उसको कम फाइन भरना पड़ेगा. ठीक है, whatever the court may feel, right? For example, Supreme Court in a case has held that quantum means quantity or the amount of penalty or punishment sentenced by a court martial on any army person should not be disproportionate to the offense. Means the amount of punishment or penalty that you are giving, that you are imposing on a person, that should not be disproportionate to the crime or to the offense that he has committed. A person has just, for example, stolen something, stolen a book, okay, and he is given the sentence of life imprisonment. It is highly burdensome. It is highly appropriate to the crime that he has committed. Okay, so this is how the proportionality principle is checked. Okay, now next lecture we will be doing this basic structure and then our chapter will be completed. Thank you.